Many of the 3 or 4 of you out there listening to this have had clients that you just want to punch directly into the teeth? I know that I have. I'm raising my hand, even though you might not be able to see me. So is that a fireable offense? Can we take our contract with that client that we've now knocked their teeth out and rip that contract up? We're going to find out about that today's video. Check it out. Hey out there, welcome back to Wedding Industry Law. My name is Rob. I am a wedding industry attorney. And if you've stumbled upon this channel, you are one of the few, the brave, the mighty. We talk all about running a wedding business legally, from trademarks to conflict to disputes to contracts, the whole gambit, everything in between. In this video, we're talking about whether or not you can terminate a contract with a client that you hate. So I want to make sure that we frame this correctly moving forward in this video. I'm not talking about instances in which the client hasn't paid you. I'm not talking about instances in which the client has punched you in the teeth. I'm not talking about the client's kicked your puppy. I'm just talking about a general dislike of someone's personality. Maybe they're getting a little bit too aggressive. Maybe they've cussed a couple of times, but the area between this person has done something criminal or super big deal to, I just don't like the Atlanta Braves and they love the Atlanta Braves. Okay. So we're talking about this gray area in the middle. Just, you're not enjoying the cut of their jib. They're being a jerk in your estimation. That's what we're talking about in today's video. And so kind of with that out of the way, with regard to firing the client, what I'm talking about is telling them that you are not going to work for them anymore and that the contract is terminated and perhaps they get some money back, or maybe they don't get any money back. This is the perspective and the framing that we are working with. And so when we say for our client and we do those things, what does that really mean from a legal standpoint? When can you fire a client like that? So the idea here is that you typically can only do that if the client is in what's called material breach of contract. Material breach of contract is a term of art. It actually means something. Not all breaches are the same. Not all breaches will have the same outcome. So for example, if you're 5 minutes late as a wedding professional, if you're a DJ or photographer, whatever it is, if you're 5 minutes late to your stated time of you're going to get there, then technically you're in breach of contract. But the rights of the aggrieved party, the rights of the clients, are much different, you being 5 minutes late, than from never having shown up at all. So there's a spectrum of breach with not really, it's really incidental to your obligations, or it's not very meaningful. So just a typical breach. And then on the other side is material breach. And so when we fire a client, that is going to be on the far end of the spectrum, material. And why that's an important distinction between just breach and material breach is that the outcomes are different. With the regular breach, typically the parties have to keep trudging along. So even though they might be mad at you for being 5 minutes late or an hour late or whatever the breach is, the parties typically will still have to fulfill the remaining obligations. They're still going to have to pay you. You're still going to have to perform. You have to move forward with the contract. With the material breach, on the other hand, typically, if it is in fact a material breach, that will extinguish or terminate the obligations of the non-breaching party. So if there's still payment left, they might not have to pay you. If they've breached in their material breach, then you might not have to perform anymore. So the difference is, one, you got to keep going, and the other is party's over. So what are the categories of breach of contract? Kind of what are we talking about? So there's material breach of contract by conduct. So that would be something like if they sexually assaulted you, for example, they kicked your puppy. They've literally told you that they're not going to pay you or they're not going to get married. These can be considered material breaches of contract. Then you have material breach of contracts that are agreed upon by the actual parties in the contract. So in other words, if you've ever seen things like time is of the essence, that's typically saying that whatever is of the essence is material. So a lot of times that's payment. Payment is of the essence. Time is of the essence for payment. Typically means that now we're saying that payment at a certain time is material, and if it's not done at that time, then all bets are off. So in other words, you can have material breach through conduct, how somebody behaves, or you can have material breach defined, and whatever the mechanism is that occurs, it will be considered a material breach. So in essence, material breach is major issue leading to a major ramification. So does being a jerk, being an a-hole, is that material breach in the first category, like the conduct? Like my conduct is the client's a jerk, being aggressive, maybe cussed a few times. That is a very, it's not objective. I think it's very subjective. Like one person's a-hole is another person's just being assertive, right? So I see this, at least in my experience, working in really different parts of the country. I'm licensed in California, New York, Florida, Georgia, Tennessee. So I'm West Coasting it, I'm Northeasting it, I am Southern, okay? And I'm Southern born and raised. So when you're dealing with clients that are from, say, Northern New Jersey, and the vendor is from, North Florida, Northeast or Northwest Florida, they might consider aggressive a little bit different than the other. So like I guess what I'm trying to say is, just on conduct alone, and again, we're in that middle gray area. Like if they've kicked your puppy, that's different. I'm talking about if it's just you think that they're a jerk, or maybe they yelled at you a couple of times and embarrassed you or whatever it is, it's hard to say whether or not that's going to be considered a material breach, which would allow you to leave the situation, which would allow you to rip that contract up. It's very difficult. The only person that's going to be able to do that for you and decide whether or not that is in fact a material breach of contract is going to be a judge or a jury down the road. So that's what we need to think about when we are considering firing a client for being an a-hole, is you better be right about it, or you, in fact, could be the one that's breaching the contract. It's possible. I mean, I'm not saying that you can't fire somebody for being a jerk, right? It's possible, but it's also possible not. It's very fact dependent. But what about, Rob, I'm just going to put it in the contract then. You said that we can make things material by the writing of the words, the writing in the contract. Why can't we say don't be a jerk in the contract and make that material? Well, that's the issue, really, is it's even hard to write that, right? It's difficult to say don't cuss, or if you cuss around me, that's material breach. Or if you write in all caps in your emails, or you're snarky in your emails, or you're demeaning in any way to my staff. These things, we're saying them, but then you got to show evidence of that, and that's difficult. So even if you could really spell out what it means to be a jerk in your contract and hold the client to that, you're still back at the same place of trying to convince a judge that, yeah, this was snarky, or they yelled, or they cussed, or whatever. So it's also, in my experience, difficult to contract around that gray area of being an a-hole. You can do it, and I've seen it, but it is a difficult process to make, to execute, because a lot of times it's the riot act. You've got to, it takes a lot of words to really put that into an actionable and enforceable term. And again, like I said, even if you are successful and you're adding an extra page essentially to your contract, it's oftentimes you're back at square one trying to convince a judge, yes, this person was snarky, this person yelled, or this person, whatever. And if you look at my contract, they can't do that, right? It's a difficult thing to do. What can you do if you don't want to have to work for a-holes? Well, the best defense against this is going to be your vetting process. In other words, don't take on clients that are a-holes. Have your set of red flags, and you know these. If you've been doing this long enough, you know that you might click with some people and some people not, and there's nothing wrong with that. You don't click with them. Don't take those clients on. So having that screening process where you're essentially observing, vetting them from the very beginning is going to be critical to minimizing the times that you want to fire a client. But let's just say that, well, Rob, I don't care. Like, I still want to be able to use my contract to fire a client. How is that done? Well, very carefully. It's done very carefully. So the best, I'm not saying legal advice, because again, if you do not rely on this video before you redo your contract to be able to fire a-holes. Okay. So this is not legal advice, but the recommendation is whatever the actionable item is, whatever the thing that really burns your toes, gets your goat, sticks in your craw, whatever it is, you need to make sure there is an objective, there's an objective way to know that that's happened. So for example, if it's don't call more than once after 5 p.m. That's easy. Like, we know when somebody we know when somebody calls or doesn't call more than one time after 5 p.m., for example. Or say if profanity offends you, then you say under no circumstances should profanity be used, profanity defined as XYZ out of the Webster's dictionary. So that way we're not splitting hairs about whether, butthole is a word that you don't want to use. So you try to set the triggering mechanism for whether or not they're fired as objectively as possible, so that it's not subjective. It's not, well, two people are going to really disagree about it. They need to see it, and it's objectively, yes, that's right, I used an expletive, or I called you past 9 o'clock. As objective as possible. But I highly recommend, though, that before the DEFCON 5 happens, where you terminate that contract, is you allow the client to mitigate, meaning try to make things right. So you give them a warning. Hey, listen, you use an expletive with my staff on Tuesday. They told me this. If that happens again, blah, blah, blah. Or, you've done X, Y, and Z. This is a warning. You get 1 or 2 warnings or whatever, allowing the client to make things right or not do it, put them on notice again. So these are things that are going to help, because it's in the process of doing that, you're further laying out what behavior is good and what behavior is bad, and taking it out of the hands of the judge or jury down the road, since you're trying to define it then. So again, if you must do that, if you must have that built into your contract, then that's, I think, going to be the more enforceable, the more likely to be enforced way that you can do it. But again, the trade-off is that your contract is a lot of valuable real estate, and the more words you dedicate to one thing, you might need to minimize from another thing. Otherwise, you're going to have a contract that's 15 pages. So that's something that you want to really think about before you do it. So again, at the end of the day, can you fire a client for being an a-hole? Yes, you run a lot of risk. Can you fire a client for being an a-hole if it's in your contract? Yes, but the risk is that your contract is going to be long. The risk is that you're going to be right back from where you started. So the idea is to try to make things as objective as possible, so that way it's almost like a yes or no situation, rather than, well, I don't know, I think if saying butthole is okay, right? So trying to take it out of that realm. So I think that's all I can say about this topic at the moment. If you liked the cut of my jib in this episode, please be sure to like and subscribe. Although I'm trying to make this the least popular YouTube channel dedicated to wedding industry law, but I'll take a few more subscribers. That's okay with me. If you have ideas or questions, please be sure to comment down below. New videos just like this every Monday. And with that, folks, we'll see you next time.